looking at Panos. Are you ready? Hi everyone. Welcome to the afternoon session, panel 2. My name is Frans Nelissen. I'm from the University of Groningen and a colleague of Panos. And let me start with expressing my thanks to the organizers, to Panos and his team for inviting me to this beautiful city. I love Athens. And to this lovely conference with this intriguing theme, the interpretation of customary international law. And panel 2 then devoted to precisely this in relation to human beings and their environment. I tend to differ a bit on their environment, I must admit. I would rather prefer the environment. Their environment brings us back to 1972, Stockholm. And we were way beyond that. But let me not take much time. What I learned from Helen this morning is very easy to take a lot more time. So I follow you. I won't do lengthy introductions. We have the nice booklet. And directly go to the speakers. I promised Panos that I would keep it within the allotted time. That is maybe 15 to 20 minutes more, but not much more. I will be lenient. So let's go to the first presentation, and I think we are all looking forward to listen to Akis. I hope I pronounce it correctly, Papastavridis. And already this morning there was a reference made to your topic. We're all, of course, highly interested in the recent judgments of the ICJ and your discussion. The floor is yours.
Thank you, Chair, and many thanks to my dear friend Panos and also Athens, my university and my institution for hosting this event. It's great. It's also great to share this panel with very, very good friends, which we had drinks yesterday, actually, preparing for this, today's conference and panel. So I know there's a lot of anxiety to listen to the case. Also was mentioned like 4 times by Mr. Laliana and Panos. So I will try to live up to their expectations. My topic is interpretation of customary international law of the sea, a huge topic, but I will try to narrow down to the 2 very recent cases of the International Court of Justice. The one on the alleged violation of sovereign rights and maritime space in the Caribbean Sea between Nicaragua and Colombia. And the second one, again, between Nicaragua and Colombia, concerning the delimitation of continental shelf beyond 200 nautical miles. So I was saying also yesterday to my friends here, thank God we have Nicaragua and thank God we have Colombia, because Nicaragua has been almost since 1986 going to the court very, very consistently, and also thanks to Colombia, because Colombia, being not a party to UNCLOS, so not applying actually treaty law, we have to apply customary international law. So in 3 cases, the one 2012 with respect to the delimitation of the continental shelf and EEZ between the 2 states, and also in these 2 cases, the court applied exclusively customary international law, which, to no surprise, it found that it's actually identical to UNCLOS. So back in 2012, they found that, for example, the limitation of maritime spaces, what is an island, is actually the UNCLOS provisions reflect customary international law. But I will try to focus only on the 2 recent cases. And the first one had to do with in the aftermath of the delimitation in 2012. Colombia did not like very much the decision of the court, so it started actually stopping fishing vessels of actually Nicaragua within the Nicaraguan EEZ, actually doing its own scientific research and its own fishing expeditions in the Nicaraguan EEZ. Also proclaimed an integral contiguous zone in the maritime space. And it had a lot of, this provoked, of course, the objection by Nicaragua, and they went to the court. Also, there was another pending case having to do with the delimitation of the continental shelf beyond 200 nautical miles, so the outer continental shelf, which was decided in 2023, very recently in July. So with respect to the first case has a lot of issues when it comes to EEZ, continental self, condicuous zone, and other kind of issues concerning the law of the sea. I will try to focus in two, because of the constraints of time, on the interpretation by the court of the contiguous zone and the straight baselines, what is fringe of islands actually, and I will get back to this. And then I will refer to the most recent case having to do with the relation between the continental shelf and the EEZ, and whether there is a right, an entitlement to have a continental shelf beyond 200 nautical miles, which actually will go, within another, opposite states with its EEZ. Now, it is important with respect to this, and put this in the context of the present conference. These two cases and these issues are important because the court didn't have specifically in the first case, didn't have to establish the existence of customary international law. It was there. Everybody knew that it was, there is EEZ, there is contiguous zone, there is straight baseline. Since the time of 1951 fisheries case, we knew Article 7, for example, of UNCLOS is customary international law. But in applying to the specific, facts of the case, the court did interpret the respective customary law. And also in the last case, in the recent case, the latter case, where it had to discuss the issue of continental self, again, it was already well known, well established that we have a customary international law. So I think these two cases deal exactly, fits neatly what Panos and his team is doing about interpretation and the rules of interpretation of customary international law. So the first case, and the issue of contiguous zone. So in Article 33, the convention actually replicating the old Article 24 of the Geneva Convention actually sets out what is contiguous zone. Nicaragua was of the view that contiguous zone was, the customary international law was identical to Article 33, whereas Colombia said that the customary international law has changed. So we can have actually broader contiguous zone that will overlap with the Nicaraguan EEZ, and also that other matters could be included in the powers of the state. For example, drug trafficking, piracy, protection of the marine environment, security, all these were powers that the state may exercise with respect to vessels within its contiguous zone. Now the courts start saying that, Article 33 goes to the drafting history of Article 33. It says that this is, states consider this as customary international law. There are 100 states that actually have declared the contiguous zone. Therefore, it is, no doubt that there's a custom. And in order to find what this, the customary international law is all about, the court actually went back to the drafting history and said that, for example, when it comes to security was proposed to be included within the powers of the state, but this was actually rejected by the drafters of the treaty. Also back in 1956, the first Geneva Convention on the contiguous zone. And also that the ideas of, let's say, protection of the marine environment could not fall under the scope of sanitary measures. Just to refresh your memory, in the contiguous zone, you can take measures with respect to fiscal, immigration, sanitary, and customs laws and regulations. Also, drug trafficking could not be, included within the customs violations. So the court said that, based on the text and the drafting history, the travaux préparatoires, we interpret Article 33 under customary international law, contiguous zone under customary international law, identical to Article 33. But it was not the only interesting thing that the court said. In actually discussing the breadth of the contiguous zone and where it can actually extend, it said that you can have a contiguous zone overlapping with another state's EEZ. So it could go, the contiguous zone of Colombia could overlap with the Nicaraguan EEZ, which was interesting because we haven't come across again this, and Nicaragua was against this argument. But the court said no, we can do this and interpret actually the powers of the state, using I think more like an effective interpretation, right? So try to make everything having sense in terms of what kind of powers states may exercise in this regard. Also, again, very interestingly, mentioned that when you have a contiguous zone overlapping with another state EZ, you must pay due regard. But due regard is not within Article 33. So due regard, however, there is replete in the convention. There is in Article 58, paragraph 3. There's an Article 56, and there are many provisions of UNCLOS that actually refer to due regard. I think here it's a very clear example of contextual interpretation. So the court interprets customary international law and contiguous zone as applicable to the EEZ of Nicaragua, as including also the idea of due regard, therefore the idea of actually something which is in another provision of UNCLOS. In addition, it's said that in respect of what powers the state may have within its contiguous zone, it's said that under customary international law there is also the power of states to use customs powers and fiscal, all these contiguous zone powers with respect to archaeological objects. And said that Article 303 of UNCLOS is customary international law that actually protects the historical and archaeological objects, and also that the state has the power to actually enforce these laws within its contiguous zone. Again, another interesting point, drawing heavily from the history and the drafting history of the convention, said that the archaeological object and the power to actually regulate archaeological objects and enforce has to do with fiscal, immigration, sanitary, customs laws, which if you read textually Article 303 and Article 33, this is not the obvious conclusion. So I think here the court goes, again, a little bit of a progressive interpretation of what is contiguous zone under international customary international law, relying, I think, heavily on drafting history, and quotes actually the National Law Commission and the Third Conference of the Law of the Sea, and also subsequent practice of states. So another hint of how the court interprets customary international law. Moving on to the second point on that case, the fringe of islands. So Article 7 of UNCLOS says that you may draw straight baselines when there is a fringe of islands in the vicinity of the coastline. And there is a dispute of what is fringe of islands under customary international law, right? And the court there says that we can have have insights from different case law, case law that has been already there, like the Eritrea-Yemen case and other cases, and actually read as fringe of islands the idea of that you have to have a connected, integrated system of islands, a cluster of islands, and also, again, an interesting point in terms of interpretation, it says that we have to also pay emphasis on the ordinary meaning of other authentic languages. So it looked what is the term in French. So I will crucify my French. It says "s'appelait des îles." I'm sorry for this. It was a very bad try effort to speak French. So it was like said, okay, this is. This attests to my interpretation. You need to have a cluster, a carpet of islands. Now, moving to because I think time flies, moving to the most recent case and the most, controversial case, the case of Nicaragua-Colombia with respect to continental shelf. Now, in this particular case, the question was as the court puts it, was very simple. Can a state have an entitlement to continental shelf beyond 200 nautical miles, which this entitlement will overlap with another state's EEZ? And this under, of course, again, customary international law. The court, I think, for its own reasons, disposed the question from the scratch. It didn't go even to the delimitation. So the first, a major point of criticism has been that, as by Judge Charlesworth, by Judge Tomka, Robinson, that the court should have delimited the respective continental shelf and EEZ, continental shelves and EEZ, and maybe it could have reached the same conclusion based on the equitable solution, on the the equitable principles under the law of maritime delimitation. The court did not do so. So the court says that under, again, using the text as its anchor, its hook, says that we have under how the text Article 76, Article 56 on the EZ are framed, how the drafting history of the convention is actually gives evidence to us. What is also referred to in paragraph 48 to the preamble as an object and purpose and a purposive interpretation that, there must be, we have to look all maritime zones in their own context. Using contextual interpretation, again, very importantly, Article 82 says that if we are actually, it doesn't make sense to have Article 82 and, which says, shortly that you have to pay contributions to the International Seabed Authority when there is actually, you have an extended continental shelf within another state EEZ. So, the purpose of this, the continental shelf and the outer continental shelf is, and the delineation of the continental shelf is not to encroach upon the area, the seabed that is actually belongs to the common heritage of humankind. Therefore, the court said that there is no right entitlement to have a continental shelf beyond 200 nautical miles. And it's used to also, and this again has been criticized, it used also, it looked at the state practice on opinio juris in the infamous paragraph 77 saying that, states have a very fragmented practice when they're actually making submissions to the Commission on the limits of continental shelf. They do not actually go in areas, they don't propose elements to going in the areas that there is within the EEZ of opposite states. However, the reason for this is mainly not to avoid legal conflict. So they don't make this by legal conviction, by opinion use, but they make it for political reasons and for reasons of expediency. Because if the other state actually objects, the Commission has to actually suspend the review of this submission. Therefore, the court says that even though there is that states have abstained from applying, in this kind of areas, not by legal conviction, but by other reasons, I find the court finds practice on opinion juris in support of its main argument. And then it says that, because there's no right entitlement to continental shelf beyond 200 nautical miles in this specific context, there's no reason for me to do any delimitation. Now, it seems here that the court is based again in the interpretation of the court, and which is, I think, closely related also to identification of customary international law, not only interpretation but also identification in this regard, specifically in this regard, is again based on the history, drafting history, on the text, on the context, right, and also in, I think, the object and purpose, and also if I can say also an idea of effectiveness, right, in this regard. Very strong criticism, again, with the idea that the court should have actually delimited has proceeded the delimitation. The court, Charles said, as mentioned by Panos, that it should have used a methodology of interpretation of customary international law, right? And the court avoided to do so. And we have to also discuss in the Q&A. I know that my time flies, so I'll just move to the conclusions. So all these the two cases and the three scenarios, the contiguous zone, the straight baselines, and the continental shelf versus the EEZ. What kind of lessons can we learn for the purpose of the TRICI project? My general conclusion is as follows. I think that, when it comes to the interpretation of customary international law, which actually is based on a text, on a treaty, it's very difficult to depart from the treaty, from the treaty interpretation. So in this regard, I think that's the interpretation by proxy. It's your first principle, the second article that you are sent as Panos. It's the idea that you have to rely heavily, you anchor your interpretation on the text, and mainly, as it says, evidenced by the court's decision, mainly on the travaux préparatoires, on the drafting history. So the court on this kind of scenarios here, they just started looking at the travaux préparatoires, right? A second also, conclusion could be in this regard that they also look at the context. So I haven't seen this contextual interpretation in your principles, Panos. It seems in this kind of scenarios that contextual interpretation, as the court did, for example, in the Equatorial Guinea, France case, or the UAE versus Qatar case, it actually relies a lot on the contextual interpretation. So in this kind of situation, we have customary international law, which actually correlates with treaty law. I think that travaux préparatoires context is something which is really important. We have less evolutive interpretation. The court seems to actually advocate here that we have a kind of static interpretation when it especially comes to the contiguous zone, and this has been also criticized by Judge McCrae. And also, I think like there is also segments of hints of effectiveness in terms of interpretation and also purposive interpretation. So I think all this can be also filtered in your final conclusions, and we're going to hear in a couple of hours. And with this, I thank you, and I'm sorry if I took the time from the other speakers. Thanks so much.
Thank you, Eikis. Thank you. Thank you for so well explaining how the court interprets international law in these recent cases. And we directly move on to Seline, our second speaker, who will now deal with the courts and its indirect dialogue with treaty bodies. Seline, the floor is yours.
Thank you very much. Good afternoon, everyone. Sorry, the mic was off. Thank you so much to Panos and the team and the organizer for inviting me. It's always a pleasure to be back in Athens and to have the opportunity to exchange with the colleagues here and from other places, to get new colleagues also. So the dialogue that I'm going to discuss today is actually silent, which is even more tricky, if I may say. Which, by the way, I've always said the name of the project. I always say TRICI, which is my Italian accent, and I'm really sorry for that, but I will be careful from now on. So, as I mentioned also in the abstract that you can see in the booklet, the idea of my presentation is really to look at how actually treaty bodies, in particular in environmental law, have been informing the interpretation of customary rules. And in that, I depart a bit from maybe the main theme of the conference and of most of the presentations, which very much focus on the role of courts, but I will link it also to how the courts actually reason and indirectly use the work of treaty bodies. And then I decided, of course, to focus on one specific obligation because it is quite broad, and I picked the obligation of environmental impact assessment because, well, that's where we have also case law, of course, so courts which have discussed the existence, first of all, but also the content of the obligation. And this is also where we have an extensive practice from treaty bodies detailing the content of the specific obligations. And courts, at least to my knowledge from the cases that I have had a look at, don't usually refer to the instruments developed by treaty bodies, but at the same time they seem to actually use the same type of reasoning and the same type of approach to the specific obligation. So what I'm trying to actually argue here is that by looking at what the treaty bodies are doing, we can also actually have information about what is the relevant practice and what is the opinion juris also of states who are, of course, active in those treaty bodies. So it's kind of this silent dialogue. And the starting point is actually just a statement from the ICJ in the very famous and discussed case of the pulp mills. Case where, so for the first time, the obligation of environmental impact assessment was affirmed as a customary obligation, so a requirement under general international law. That this is the wording of the court, and in particular, the court says that the rules and measures, which in this case Argentina and Uruguay have to adopt to implement that obligation, should also reflect their international undertakings in respect of biodiversity and habitat protection. So from that paragraph of that statement of the pulp mills, I started wondering what are those undertakings in respect of biodiversity? How do I delimit also those undertakings? It's, of course, the CBD, the Convention on Biological Diversity, but the court didn't say the Convention on Biological Diversity, it says the undertakings for the protection of biodiversity and habitat, which then is the wider and looser category of instruments and eventually standards and rules. So that's how then I bring in the work of the treaty bodies of the CBD, of the Convention on Biological Diversity, but not only, because actually not only the Conference of the Parties of the CBD worked on this specific issue, but also the Ramsar Convention on Wetlands, for instance, or the Convention on Migratory Species, or also CITES. So the treaty bodies of all those multilateral environmental treaties have actually developed and contributed over time to shape the content of the obligation of environmental impact assessment. And just to confirm, in the 2015 construction of a road case, the ICJ also further mentions that determination of the content of environmental impact assessment should be made in light of the specific circumstances of each case, which included then in the analysis of the court, actually the analysis of the relevant obligations under the Ramsar Convention and the practice within the Ramsar Convention. So the need to really look at the broader picture in order to identify the content. So as I said, it's a bit of a silent dialogue, but I think the dialogue is there. In this presentation, also, to use the words of Dr. Mileva, I look at the concretization function of the interpretation of customary international law. More specifically, I look at interpretation as specification. So when the interpretation of custom makes the content of a general customary rule more specific by fleshing out sub-obligations that flow from the general rule. So how is that obligation of environmental impact assessment then detailed and shaped by the court using then the work done by the Conference of the Parties and the different treaty bodies that participate in shaping that obligation. I'm not going to go through all the cases. For the sake of time in this presentation, I want to focus on the 2016 Annex 7 arbitral award in the case of the South China Sea. And hopefully, in the paper that will follow, I will include also actually the Inter-American Court of Human Rights and its advisory opinion of 2017, where there is a similar kind of approach there. But for this presentation, as I said, I would like first, in just a few minutes, delineate the obligation of environmental impact assessment within the CBD and the main work done by the Conference of the Party, and then to see a bit how this reasoning has been used by the Annex 7 Arbitral Tribunal. So environmental impact assessment is an obligation which is core in the Convention on Biological Diversity. It is in its Article 14. But in order to support actually the integration of biodiversity considerations in environmental impact assessment procedures, the COP of the CBD adopted in 2006 the voluntary guidelines on biodiversity inclusive impact assessment. Voluntary guidance from now on. So I'm not going to enter into the lawmaking powers of Conference of the Parties. This is beyond the presentation of today. We can maybe discuss them during the Q&A if there are any questions on that. But the voluntary guidelines of 2006 are considered to have high normative value because they have been negotiated under the auspices of the CBD and adopted by the Conference of the Party. And just to make a comparison, we have also draft guidance on biodiversity inclusive strategic environmental assessment, which have been adopted by the Secretariat of the CBD, which are considered of less normative value. So here the normative value of the decision comes also from the fact that it has been adopted by the plenary body of the treaty. So, and that's why I focus on those. Moreover, the 2006 voluntary guidance also benefits from external support of other guidelines documents with a similar content. So, for instance, the resolution of the Ramsar Convention, Conference of the Parties of 2008, refers to the guidelines of 2006 of the CBD, and the same also the Convention on Migratory Species, Conference of the Parties, referred to the 2006 CBD guidance. And we can see a sort of supportiveness or mutual kind of reinforcement of those principles and recognition of those standards as the relevant standards and the agreed standards for environmental impact assessment within biodiversity protection. So now, in the voluntary guidance in particular, and I'm not going to go through the whole text of the guidance, don't worry, but what the interesting part of the guidance is that they spell out the phases of environmental impact assessment. So they look at what is a state supposed to do when organizing an environmental impact assessment procedure. And it should start with screening, then scoping, assessment and evaluation of impacts, development of alternatives, reporting, review, monitoring, and compliance. So this is very clear in the guidance, and then there are more details on how to incorporate in each of the phases biodiversity considerations. Now, in the arbitral award of 2016 in the South China Sea case, the arbitral award applied the CBD, but because it was also the applicable law within the parties. But it also very clearly mentioned the customary nature of the obligation of impact assessment and referred to previous cases from the pulp mills to, of course, the ITLOS Deep Seabed Chamber advisory opinion, saying in particular that this is a general obligation under customary international law. Then, while looking exactly at what is the content of that obligation, the tribunal goes through a series of arguments, linking it, first of all, to the relevant Law of the Sea Convention provision, Article 206. So Article 206 of the Law of the Sea Convention is then interpreted jointly with the CBD, but also with the broader context of customary international law, as it also looks at actually what are the, as custom is also applicable, of course, in the case at hand. So it looked at exactly the phases that I mentioned earlier. First of all, it looked at the scoping and the screening. So what are the type of location, what are the type of activities, what is the impact. In order to do so, also as China was not participating in the procedure, the tribunal had expert panels as experts who, am I fine with the time? I'm looking at you, sorry, I thought you were trying to tell me to. It asked also experts to collect that information in order to go through the different steps. It had, of course, the data also brought by the Philippines, but they were complemented by those other data. Here, there are different interesting aspects of the argument of the tribunal. One is that Article 206 is described as an essential part of a comprehensive environmental management system. So as environmental impact assessment, Article 206, part of a broader legal context which is supposed to then manage natural resources and also include, of course, the protection of biodiversity. It also makes a link and a reference to the Chagos case, the Chagos Marine Protected Area case. different cases. Let's not confuse them. The one on the marine protected area, where it is also clearly set that the obligations under Part 12 of the Law of the Sea Convention and the protection of the marine environment is not only about controlling pollution, but it is part of a broader management system and protection of ecosystem. Protection of ecosystem, which is then not defined actually by the Law of the Sea Convention, and then here again the tribunal refers to the CBD as the source of the definition of what an ecosystem is. As I said, the tribunal does not clearly use the words screening or scoping. But if you look at the structure of the award, in particular where it discusses Part 12 of the Law of the Sea Convention, it recognizes the different phases spelled out by the 2006 voluntary guidance. And in order to do so, as I mentioned, it uses different reports. And here I want to focus mainly on the paragraphs concerning China's construction activities of 7 reefs in the Spratly Islands, which is where the reasoning is a bit more detailed. For the scoping, it used in particular the FERSA report, which includes an assessment of the extent and the likely duration of the harm. Then the assessment and evolution of impacts are actually also assessed on the basis of data gathered from Chinese scientists. And those data include the timing of the works, the water quality, the restoration and transplantation of reefs, which includes also this element of considering alternatives, and the overall impact on reef structure and health. And then it also looks at the use of natural simulation methods as possible alternatives. The tribunal also points out in paragraph 990, if you are interested, that Chinese legislation actually integrates the same steps, the same standards. So it looks at how those different phases are actually regulated at the domestic level and are then in compliance with the international legal framework. Then the tribunal actually at the end cannot make a definitive finding on whether China did or did not perform a proper procedure, because it didn't have actually, China never submitted the relevant documents. But even though, notwithstanding that, actually the tribunal makes another important statement which complies again with one of the steps of the phases of the guidances, that it is part of the environmental impact assessment procedure to communicate, to notify also the outcome of the procedure. And in this case, indeed, China was found in breach of Article 206 and of its obligation of environmental impact assessment because it did not communicate the outcome of the procedure to the relevant parties. And this part of the communication of the results of the procedure is also one of the steps, one of the phases of the environmental impact assessment procedure, which is also referred in the 2006 voluntary guidance. So, to conclude, as I said, this is more of a, well, maybe I raise more questions than I give answers, but I thought it was interesting when I was approached by Panos for this conference to look at how also those concepts are shaped and interpreted by other bodies than courts. And indeed, courts, when they rely on identifying what is the relevant practice, is the states, where is the relevant practice of states in environmental matters? Well, it is also within the treaty bodies, the type of decisions that they adopt, the type of legal framework that they create, that then they implement at the domestic level. in addition to this case, as I said, in my final analysis, I will also include the advisory opinion of the Inter-American Court of Human Rights, because in that advisory opinion, for instance, also the court, while again going through the different phases of a procedure of environmental impact assessment, actually mentions also all the domestic legislations which comply with those different phases. So it is interesting to see how also there is this dialogue at different levels between the court, the treaty bodies, and the domestic level in shaping and defining the content of those obligations. So courts, of course, have still kind of the monopoly to a certain extent of identification, but maybe not of interpretation. And I think that this is an interesting case to pursue, and I look forward to your questions. Thank you.
Thank you, Seline, for explaining so well how courts make use, maybe I should say, silently, the works of these treaty bodies. And interesting questions. I'm sure we come to those questions, but first we move on to humanitarian law. Fios, can I give you the floor?
Yes, please. Thank you. Okay, I would also like to thank the organizers and Panos in particular for inviting me. I have to say up front that when we discussed the topic with Panos, I was skeptical about the idea of having rules of interpretation of customary international law. I was, or I am, it remains to be seen, among those who rather are drawn to the content merges with existence approach, which is why I was happy to engage in the exercise of trying to figure out whether in the specific set of rules of international humanitarian law there was some interpretation of customary law, and how did that happen. I do not, of course, pretend to have looked into everything, but I have looked into positions by states, a number of case law, including a precedent that is not well known, which is one of the Eritrea-Ethiopia Claims Commission, which is an arbitral commission that was put in place after the end of the 1998-2000 conflict between Eritrea and Ethiopia, and which is interesting for our purposes here. My objective is to look into three questions, the ones that structure also Panos' paper. Is customary international humanitarian law interpretable? And that's the basic premise. My answer to this question on the basis of the material that I have looked into is that yes, customary IHL can be interpretable. My next point will be, if it is interpretable, then how it is interpreted. Are there any methods, practices that are systematically followed in the interpretation? Here my answer is more mitigated. There's either not much interpretation or not much consistency in the methods that are used for interpretation. And then my third point will be, if customary law is interpretable and interpreted, are there any limits to its interpretation? And here my answer would be not really. So I will check the points one by one. On the first question, is customary IHL interpretable? The answer is yes. We have one example that comes from the study of customary international humanitarian law rules conducted by the ICRC legal advisors. They looked into state practice for over 10 years. In 2005, they published a book with 161 humanitarian law rules, which they found to be customary. And for many of these rules, you have a section, aside from the section on practice and opinio juris, you have also a section on definition, and also sometimes a separate section on interpretation. So there seems to be a distinction that is made by the ICRC between the establishment of the rule and its interpretation. The second example comes from that commission I was discussing about, the Eritrea-Ethiopia Claims Commission. Why is it interesting, this precedent? Because in the conflict between Eritrea and Ethiopia, at the time of the conflict, for most of the conflict, Eritrea was not party to the Geneva Conventions, let alone First Additional Protocol and everything else. So all the law that the Commission used in the arbitral awards dealing with humanitarian law was based purely on customary law. And then if you look at the arbitral awards, they start out with a section which establishes the applicable law, and in that section the Commission says the rules of the Geneva Conventions and most of the rules of the first additional protocol are customary, and the parties agree to that, and that's the end of the determination of the existence of the customary nature of the rule. And then at the second stage, we go on to the interpretation or application of the rules to the facts. So there again, the general structure of the awards seems to indicate a distinction between the law ascertainment phase and then the interpretation phase. Now, if this is the case, and then if international humanitarian law is interpretable, then how is it interpreted in practice? Well, a preliminary point first, the lexical garment here is, first of all, treaties. We have many treaties on international humanitarian law, and for most, really the big majority of the customary rules, you will have a text to which you will refer to. And if you don't have the treaties, you have at least the study by the ICRC, which is to humanitarian law what the ILC 2001 Articles on State Responsibility are to the rules of state responsibility. So you do have a reference text. One would expect then, when we go to interpretation, to be more easy to go to the rules of interpretation of the Vienna Convention, and this doesn't really happen. In most cases, the interpretation is presented as self-evident and there is no real justification. When the ICJ, for example, in the DRC versus Uganda, looks into the definition of occupation from Article 42 of the Hague Regulations and says that's customary, and then it applies it to the situation and says, well, occupation means you need the substitution of authority. We don't know why, because it's not clearly stated in the text. We're supposed to take the court's word for it. When they go on to Article 43 of the Hague Regulations, which says that the occupying power has the obligation to ensure public order and safety, the court says this obligation means that you're responsible for everything that happens in the occupied territory, including acts of rebels. Again, this is not specifically cited in Article 43. There is obviously some kind of interpretation process there, but there is no sign, no element of interpretation in the court's decision. Same thing for the Claims Commission. You apply the rule relating to the evacuation of prisoners of war, which is supposed to be done humanely. The Commission says, well, if you make prisoners walk barefoot, that's inhumane. And then there is no determination of what inhumane treatment is. There is no added layer, let's say, to the interpretation. In other cases, we have references to some grounds for interpretation. Usually here we have either the humanitarian object and purpose of the rule, or scholarships and manuals which confirm the interpretation, or some criteria that points to the reasonable character of the outcome, the reasonableness of the outcome. One example, again from the Eritrea-Ethiopia Claims Commission. This concerned the medical care that is to be given to prisoners of war once they're captured. In that specific case, Ethiopia just gave first aid. And so the question was, is first aid enough, or do you need to provide more medical care? And the Commission says, well, we have to take into account the harsh conditions on the battlefield. We have to take into account the fact that there are logistical and resource limitations to Ethiopia. So on balance, first aid is enough. There is no violation of the rule. Another example, again from the Claims Commission, is short-term occupation. Ethiopia was saying that for a specific incident, her troops were fighting and moving too quickly for them to be considered as an occupying power under the definition of occupation. Well, what the Claims Commission said is that, okay, that may be true, but then it's not reasonable to apply to you all the obligations of the occupying power, but we will apply some of the obligations of the occupying power. And then there is no added element to the interpretation except for the reasonable character of the outcome suggested. Aside from these remarks, I wanted to make one point on the scope, which for IHL is a very, very important element to take into account. We have a first group of cases which are rather simple because the scope of the rule merges with the content and what we would call in French la qualification des faits, so really the qualification of the facts. That, my understanding, is that this would be the case of cyber operations, for example. We hadn't envisaged cyber operations when we adopted the rules. We have to decide whether a cyber attack can be considered as an attack for the purposes of the principle of distinction. We were not thinking of cyber personal data when we defined what a civilian object is. Well, we have to understand whether cyber personal data can be considered and protected as a civilian object. And here, yes, states' positions do affirm that IHL rules apply, but they do not really go into a full-length interpretation and invocation of interpretative methods in order to say why they apply. Another interesting example, again from the Claims Commission of Eritrea, Ethiopia, comes from occupation of contested areas. Eritrea was found to be the occupying power of a territory that did not belong to Ethiopia. It was peacefully administered by Ethiopia before the war, but it was not under Ethiopian sovereignty. It was contested. So then naturally, Eritrea said, well, if it's my area in the end, I cannot be an occupying power of my own area, of my own territory. Well, the Claims Commission first went to the object and purpose of the humanitarian rules. And it said, if we allow the contested character of the territory to throw away or to block the concept of the occupation and the application of the rules of occupation, then we are depriving populations of a protection that they need. So in view of the object and purpose of the rules, we have to consider this as an occupation. The alternative, says the Commission, would frustrate essential humanitarian principles. And then it goes to the text, and it looks at the article of the Geneva Convention and the Hague Regulations and says, there's nothing in the text that says that only territory to which title is certain can be considered as occupied. So that's also an interesting precedent in terms of the hierarchy between the methods of interpretation. The second case, which is more complicated, relates to the rules that apply in international versus the rules that apply to non-international conflicts, because you have this major distinction in humanitarian law between international and non-international conflicts, and the rules that apply are not necessarily the same. So here, theoretically, you have two options. You either say the rule exists, it is customary, and that's the first step, and I will go through interpretation to see whether it applies to both conflicts or not. You have had this approach. You have had this approach from tribunals that favor an extensive application of IHL. The Tadic case of 1995 is the seminal example to this. We have prohibited weapons. We know that custom prohibits them for international conflicts. Well, if we prohibit them because they're inhumane, they are as equally inhumane when they are used in non-international conflicts. So it makes no sense to have the prohibition only for international and not for non-international. So they're prohibited in both. The second option would be to think of this as having two parallel and identical rules, two twin rules, one for international, one for non-international. And having established the customary nature of the rule for international, does not say anything about the non-international. If you want to say that the rule is customary also for non-international conflicts, you have to go again through the exercise of looking into state practice and opinio juris. That was precisely the criticism that the United States leveled against the ICRC customary law study, which found a number of rules to be customary also for non-international. They said, you don't have the supporting state practice and opinio juris to prove that the rule is customary also for non-international conflicts. So my suggestion here is that when the scope of the rule is contested, either in terms of international versus non-international, or even in terms of the scope itself, the preferred approach is not to handle this through interpretation, but to go back to the identification. Because the criticism, when you say you don't have the practice to prove that the rule is customary, is much more fundamental than the criticism to say you have interpreted the rule in a wrong way. And the reason why that criticism is more fundamental is because the interpretation is a flexible and complicated process to begin with. Which brings me to the third point. Are there any limits to the interpretation? Well, I'm not convinced, I have to say, I'm not contesting the theoretical distinction between, let's say, the interpretation on the one hand and modification of a convention on the other. I just think that already the borders are very porous when it comes to treaty law, and the discussion that we've had in the first panel proves this, I think, sufficiently. If you add in the evolutive interpretation, then the borders are pushed to a vanishing point. So even if the distinction theoretically exists, I'm not convinced of its practical relevance. I have one example, again, concrete example, it will be my last one, that comes from Israel's High Court of Justice in the targeted killings judgment, so the judgment that is cited also in the paper circulated. The rule in question is the one of direct participation in hostilities. So the rule says civilians are protected against attack unless and for such time as they take a direct part in hostilities. Israel, the Israeli government, contested the rule. It didn't say that the rule as a whole is not customary. It says there is a customary rule, but the rule says that you can attack civilians when they take a direct part in hostilities. They omit the for such time as. So they omit the temporal limitation. The idea behind it is that if you have terrorists that are conducting attacks, it makes no sense to be allowed to attack them only during the time when they commit the attack. You have to be able to attack them before and after. And that was their first point. So they said, the rule that you're trying to apply to us is not customary. The for such time as is not customary. And then their second point was, well, even if you are right, and even if the rule is customary as a whole, so even if the rule says you can attack civilians for such time as they take a direct part in hostilities, we can still interpret each and every term of that rule in a way as to authorize the attacks that we want to be authorized. So they say, in the end, what is hostilities? Hostilities cannot mean only actively using a weapon. What is a direct part in hostilities? It's not just taking out your weapon from your pocket, shooting it and getting it back to your pocket. It must be something more than that. What is for such time as? When you go towards a place where you will conduct the hostilities, when you will return from a place when you have conducted your hostilities, aren't you still in the for such time as you're taking a part in hostilities? So in the end, whether you consider the rule as customary or whether, I mean, with a limited scope, so modified as the Israeli government wanted it to be modified, or whether you accept the entire rule and then you're toying with the interpretation, the end result, for the purposes of the Israeli government, would be the same. The actions that they want to be justified, they would be justified. And object and purpose cannot really help us in that respect, because the court itself says, well, for this principle here, I have Cassese, one famous international law professor, who says, the object and purpose of these rules is to protect civilians. So when in doubt, we must interpret the rule narrowly. And then I have another famous international humanitarian law lawyer, Michael Schmidt, who says, well, yes, but the end objective, the final objective of the rule is to protect innocent civilians. And when you allow civilians to directly participate in hostilities over and over and over again, what you will end up with is states using force even against innocent civilians. So how and where does the object and purpose limit the interpretation of what we have here, the customary rule? My final point, and I will end with this, is that I think there is one thing that should be added to the interpretation of customary international law that I see, at least what I found as a conditioning element, and that is reasonableness. The reasonable character of the interpretation. The interpretation, above all, has to make sense. And this is, of course, linked to the idea and the principle of good faith. And with that, I will thank you very much for your attention.
Thank you, Vios. You started your talk with expressing your doubts whether this topic would be something for you, but I think you clearly managed to convince us that it is. And I'm sure that there will be questions. But before we come to that, we have the final presentation by Stavros. Protection of the environment in times of armed conflict. Stavros, the floor is yours.
Thank you, Mr. Chair. I'm also very grateful to the organizers, TRICI-Law and Athens PIL, and in particular Professor Panos Merkouris for this kind invitation to reflect on a highly topical issue. I will start with certain preliminary remarks. So the topic of my presentation, as you can see, is interpretation of customary rules in the context of protection of the environment during armed conflict. And through some mini case studies, I intend to assess the relevance of the draft articles on the interpretation of rules of customary international law, focusing particularly on the methods of interpretation. Against this background, I will delve into three distinct issues to showcase the value and the methods of interpreting customary rules relating to the protection of the environment in armed conflict. I will hereby referring to the latter aspect with the acronym PERAC, this is what we usually call it, which stands for the protection of the environment in relation to armed conflicts, even though today we'll be focusing on the in bello phase during armed conflict. In this respect, I will be dealing with two legal initiatives undertaken respectively by the United Nations International Law Commission and the International Committee of the Red Cross. The ILC process ended up less than a year ago, in December 2022, with the adoption of a set of 27 draft principles on PERAC, which were taken note of by the General Assembly, the United Nations General Assembly, in December 22. While the ICRC, the National Committee of the Red Cross, published an updated version of the guidelines on the protection of the natural environment in armed conflicts in September 2020. Both these documents are accompanied from a commentary, quite detailed, numbering over 100 pages each. Before turning to the main corpus, I deem it appropriate to provide some context regarding the lawmaking activity within the realm of PERAC and some additional details on these two legal initiatives undertaken by the ILC and the ICRC. To start with, the first landmark moment in PERAC lawmaking is marked by the inclusion of two environment-specific provisions in Additional Protocol 1, which was adopted in 1977. Of course, now we're in the realm of treaty law. We have to acknowledge that. At the same time, another relevant treaty was adopted. We call it the ENMOD Convention, Convention on the Prohibition of Military or any other hostile use of environmental modification techniques. As you understand, again, I reiterate, these are treaty-related developments. Since then, the formal lawmaking space in PERAC has remained unoccupied. To a certain extent, this gap may be filled by these two legal initiatives undertaken by the ILC and the ICRC. Now I turn to the normative value of these initiatives. As a preliminary point, and perhaps in opposition to other presentations and other topics under consideration, there is a dearth of judicial pronouncements or decisions concerning PERAC to resort to. Nevertheless, quite importantly for our purposes, the ICRC is explicitly relying on customary international law, as the 2020 guidelines affirm. They mention that this is a statement of the law as it stands in the eyes of the ICRC. Moreover, according to the commentary accompanying the ILC PERAC principles, these principles contain provisions of different normative value, including those that reflect customary international law and those that contain recommendations for progressive developments. The ILC PERAC principles I have singled out for today's presentation fall within the former prong, the codification prong. That's why they're relevant for our purposes. How do we know? Well, I have the text as well, and you can also tell yourselves. But besides that, it's a common distinction within ILC outcomes, the distinction between using the modal verb shall and should. Shall usually points towards the direction of codification. And these principles I will be discussing today, all of them are phrased in these terms, shall terms. Lastly, a criticism stemming from the doctrine of formal sources of international law, to which Panos referred in the previous panel. There was this blog, and actually it was the only reference I could find specifically on PERAC. These two authors refer explicitly to the PERAC, ICRC PERAC guidelines of 2020, and they criticize this document, saying that the ICRC merely states the customary status of certain rules, and then in order to describe their content, they interpretatively analyze a wide variety of sources beyond state practice and opinio juris. This is the criticism they levy against the ICRC PERAC guidelines, but I think it is misguided. If you have a look at the ICRC PERAC guidelines, they follow more or less the structure of the customary study, 2005 customary study on IHL. First you have the law, and then you focus on state practice, and of course you draw insights from scholarly publications. I think it is a misguided criticism. Let me now turn to the three main substantive issues. I wasn't sure about the first one, whether to include it or not, because it is not stricto sensu an issue of interpreting customary rules. But when I was going through Panos' paper, and of course Vaios also touched upon this issue concerns the civilian, the inherently civilian character of the environment. It's a matter, of course, of interpretation, but it's not like it will be reflected on a rule per se. Nevertheless, it is a very important qualification, because as long as the environment or parts thereof are qualified presumptively or at least in principle as civilian objects, then the whole machinery of IHL, at least the general rules on the conduct of hostilities, apply. It's the same discussion with cyber operations, with outer space, etc. Of course, not in the context of a new domain having emerged, and then we have to discuss whether IHL rules or some rules from international law apply. It is a very specific issue whether the natural environment per se qualifies as a civilian object as a whole. There was a discussion back in 2015 before the ILC. I was attending this session, and there were variations of the argumentation. The first one, it's a classic one we face within IHL, is that, you know what, states have never said so explicitly, or you cannot find a manual clearly, explicitly, unequivocally qualifying the environment as a civilian object. But this, of course, in my view, it's an argument that most of the time will fail, especially when it comes to IHL and the binaries that permeate the entire corpus of IHL. It is either an IAC, international armed conflict, or a non-international armed conflict. It is either a civilian object or a military objective. So I think this argument fails on these grounds. Israel, in its statement before the 6th Committee of the General Assembly, advanced a more nuanced version of this argument, saying that, you know what, we cannot accept that the environment or parts thereof qualify as civilian objects per se. They would so only to the extent that the civilian population would be affected. In a sense, this reverberates the anthropocentric approach that again transcends the entire field of IHL. But I would stick to the same counter-argument. It's an either-or discussion, so we don't have to expect that military manuals will say, you know what, all fauna is a civilian object, all flora is civilian object. No, you cannot expect these from military manuals. This is a preliminary point, not necessarily, again, I say, falling within the domain of interpretation of customary international law. But let's now turn to more substantive issues. This is the obligation to take care, or the obligation not to use methods or means of warfare that are expected to meet this, to reach this very high threshold. You will see that it is articulated in cumulative terms. All these three conditions have to be met at the same time. I have included here the various variations. The first one is the treaty document. These are the two environment-specific provisions I mentioned earlier that are found in Additional Protocol 1. Then, quite interestingly, this is the text of the ILC's document after first reading. It's not the finalized one. We have the finalized version, 2022. This is how it stands right now, the third column. And of course, the last one is the equivalent norm as acknowledged by the ICRC. This is what the ICRC believes is a rule of customary international law. It's also quite important to pay some attention to the parentheses, arguably applicable in a non-international armed conflict. The ICRC is crystal clear about this. Of course, it acknowledges that the US might be a persistent objector, together with France and the UK, when it comes to the use of nuclear weapons. The ILC is also quite explicit, and actually it has introduced these reservations in the main text, as you can see in the third column, the caveat highlighted in red. There was a huge discussion within the ILC how to include this one, and this is the compromise they managed to reach, which it could be argued that reflects applicable law. Of course, this is not about interpretation. It's just to mention that for some, still, the customary status of the rule I will be discussing is still debated. Okay, now let's delve into these three, the qualifiers, the epithets, the adjectives, this very high cumulative threshold that, as some argue, might never be reached by conventional weapons, even though there have been some claims recently following the destruction of the Novakhovka Dam in June 2023 that perhaps this is the first case that this very high threshold may be reached. How can we interpret this? Usually we resort to the travaux between 74 and 75 in the context of AP1. Of course, the discussions were not conclusive. There are some inferences we can draw. At the same time, I mentioned before the NMOD Convention. The NMOD Convention uses the same terms, more or less. Instead of long-term, it just has replaced this word with long-lasting. But there is a huge difference. The articulation of these three qualifiers is disjunctive within the NMOD Convention. Here, as you can see, in all documents, it is a cumulative threshold. At the end of the NMOD Convention, of course, there are some understandings relating to how to interpret certain terms, and you can find in the first understanding interpret definitions of widespread, long-lasting for the purposes of NMOD, and severe. And a very nice last sentence, I quote, "It is further understood that the interpretation set forth above is intended exclusively for this convention and is not intended to prejudice the interpretation of the same or similar terms if used in connection with any other international agreement." These two documents were being negotiated at the same time. They knew what was going on. there is, or at least there was some consensus on how to interpret these terms in the context of AP1, a treaty, the treaty in place. Very high threshold. For example, widespread would be definitely more than several hundred square kilometers, the area affected. This is the spatial dimension of the impermissible environmental damage. Long term, even though for the purposes of the ENMOD Convention can last for a period of months or approximately a season, some scholars were arguing that in the context of AP1 negotiations, this should be counted in decades. Huge discrepancy, as you can see. This, of course, caused the temporal dimension of impermissible environmental damage. The last element, the severe, a common term in both treaties, is about the intensity, the gravity of environmental damage. Fast forward 2020, and the ICRC delves into concrete interpretation of these terms. How does it do that? Through evolutive interpretation. It draws on ecological understandings, and also on certain aspects it combines it with teleological interpretation, mentioning specifically, for example, that with the evolution of international environmental law, there has been a growing understanding and recognition of the need to protect the natural environment and limit damage to it. And the end outcome is that the ICRC in 2020 ends up acknowledging that customary international law, the rules, these three terms, have the same meaning as the ENMOD Convention. This is the suggestion, or at least, to be precise, how customary international law looks from the eyes of the ICRC. It's interesting to note a couple of statements by states in the context of the ILC's work. I have singled out Spain's and Greece's statement in that respect. Spain, and this also ties again with the previous panel, the limits between interpretation, revision, modification of a treaty, what is acceptable or not. Spain suggests that this paragraph should be worded disjunctively along the lines of the ENMOD Convention. Suddenly, Spain comes up with this proposal that "and" should not be applicable anymore. We should rather resort to the "or" articulation. This could help lower the threshold. This is what Spain claimed at the, when submitting its comments to the ILC. A cumulative approach makes the application of the draft principle virtually impracticable. This is what Spain submitted. Greece also, on two occasions, both in 2019 when Mr. Lanyan delivered the statement, and in 2022 when Dr. Stavridis delivered the statement on behalf of Greece, both proposed an interpretation of this rule, the obligation to take care, along the lines of the principles of international environmental law, referring explicitly to the no harm obligation under international environmental law. And this is now the last part of my presentation, turning to the PERAC principles on situations of occupation. The ICRC did not deal specifically on situations of occupation, but the ILC, part 4 of its principles, are applicable in situations of occupation. The applicable law in this respect dates back to over a century ago, at least as far as environmental protection is concerned. Now I have in mind the 1899 Hague Conventions and, of course, the regulations 1907, more than a century ago. One could say that they could do with some updating, right? And the ILC came up with 3 dedicated principles applicable in situations of occupation. Principle 19, paragraph 1, as you can see, explicitly in the commentary, the ILC mentions that it draws on Article 43 of the Hague Regulations, which is reminiscent of the by proxy textual interpretation, the way the ILC interprets this one. And there is an interesting quote, again in the commentary, that this obligation to ensure that the occupied population lives a normal life as possible in the prevailing circumstances, entails environmental protection as a widely recognized public function of the modern state. This is the argumentative move that the ILC makes to adjust the realities more than a century ago to nowadays contemporary ecological concerns and ecological awareness. It goes on to explicitly mention that human rights law informs the interpretation of the notion of civil life, or public health, and these may also include environmental obligations. So co-applicability of human rights law, and through this, the inclusion of environmental obligations. And this is how we can end up with Principle 19, paragraph 2. Of course, another trope which is very common in international environmental law, environmental considerations are context-dependent and evolving, leaving room for further updating in the years or decades to come. Principle 19, paragraph 2, significant harm now is the threshold. Remember before, this very high triple threshold in bello, applicable in international armed conflict, and of course those familiar with international environmental law, you can easily identify where they drew from this notion. Of course it comes from international environmental law. Civil life and orderly government are evolving concepts comparable to the notions of well-being and development. This is what the ILC agreed to, and of course the General Assembly annexed this to the resolution, taking note of the ILC PERAC principles. Principle 19, paragraph 3, as you can see, again it alludes to the principle of systemic integration, this phrase within the limits provided by the law of armed conflict, and through this one, of course, there could be reference to the principle of self-determination or the principle of permanent sovereignty over natural resources. And here comes, I think, the most illustrative connection between the articles, or at least the draft articles on interpreting customary international law, and how the ILC dealt with this topic, especially PERAC Principle 20. The provision, of course, is based on Article 55 of the Hague Regulations. Again, it draws from the text, and then you can see how this grows increasingly. The notion of sustainable use of natural resources can be seen as the modern equivalent of the concept of usufruct. Usufruct is the idea back in the Hague Regulations of 1907, Article 55. The principle of sustainability permeating, delineating the administration, the sustainable use, the use of natural resources in occupied territory. Again, it draws heavily from international environmental law. A combination of evaluative interpretation and, of course, the principle of systemic integration. It was already mentioned in panel 1 that usually these will go hand in hand when it comes to the interpretation of customary international law. To conclude, I try to focus on the methods of interpretation, customary international law, shedding light on the ICRC PERA guidelines adopted in 2020, and the ILC PERAC principles, which were taken note of by the General Assembly in December 2022. I hope I tried to convince you that there were instances of evaluative interpretation usually coupled with the principle of systemic integration, especially when it comes to the ILC PERAC principles that apply in situations of occupation. And I hit the last point, but it seems that, yeah, it fell through the cracks, so I think I will conclude here. Thank you.
Thank you, Stavros, providing us with these recent views and interpretation by the ILC and ICRC on this important issue, on the protection of the environment in times of armed conflict. And that brings us at the end of 4 presentations, and now we have time for questions and discussion. I see a first one. You have to push it for about 3 seconds, and then it remains on.
Great. Whoa. So thanks very much. An exciting panel. My questions, I think, go mostly to Vias. I love you, Akis, you know I do. So I actually have 3 questions. I will be short. First, how to distinguish scope, extricate scope, and say, okay, it's about scope, so this is interpretation, or this is identification because it's scope. So it goes to the practicability of the criterion. Well, I can hear this idea of reasonableness. Let's negotiate here. How about good faith? Okay. And the third question is, I can hear the indeterminacy argument that, well, Israel can say, okay, there is not enough practice, there is no opinion juris. At the same time, they can also go German on us and say, okay, you say rules of interpretation of customary international law. What is rules? What is interpretation? What is customary? What is international law? It yields indeterminate example. But I mean, if that's the issue, then let's do away with all rules. All rules are indeterminate, aren't they? Thanks.
Fios, are you ready for answering? Yes.
Yes, okay, thank you very much. The difference between scope and interpretation was precisely the point I was trying to make, actually. For IHL, you have the first basic issue of scope, which is the distinction between international and non-international, but that is IHL specific, let's say. Aside from that, whether you, as in the example that I gave for the direct participation in hostilities rule, whether you will consider that the rule says civilians cannot be attacked unless they participate directly in hostilities, or whether you will consider that the rule says civilians cannot be attacked unless and for such time as they participate directly in hostilities, it is as much a question of scope as it is a question of interpretation. My point was to say that in the end, if you want to narrow the rule, if you want to narrow the scope of the rule, the preferred approach will be to say that the rule is not customary. Not to say it is customary as a first step, which is completely separate from, now that I have agreed that it is customary, let's discuss how the customary rule is interpreted. That was my point. There is another very interesting example with respect to the rule relating to attacking or destroying objects indispensable to the survival of the civilian population. You have an article of the first additional protocol which establishes the rule, and the ICRC study said that the rule is customary. The rule in the ICRC study says attacks, the destruction, etc., of objects indispensable to the survival of the civilian population are prohibited. The article in the first additional protocol says attacks against objects indispensable to the survival are prohibited when they are conducted for the specific purpose of depriving civilians of these objects. Okay? So then when the question came up before the Claims Commission and the customary nature of the rule was contested, or at least the Commission had to look into the customary nature of the rule, the Commission did not say, I have the study. The study says I have a customary rule, and now let's discuss what exactly is its scope and how do we interpret it. The Commission forgot all about the ICRC study and the fact that someone, and not a scholar or whatever. The ICRC itself found that the rule was customary. What did they do? They went back to, is there sufficient state practice and is there opinio juris for Article 54 of the protocol to be considered as customary? So they chose to go back to the existence of the rule itself in order to show that the scope was limited. So that was my point. On the reasonable question, yes, of course, it is good faith. My suggestion is it's not only treaties that should be interpreted as good faith, customary international law should be interpreted in good faith as well. And then on the third, a bit provocative question, my suggestion is just, we were discussing at the end of the first panel, the flexibility inherent in customary international law and in interpretation and all that, and the question was flexible for whom? And we're thinking about international courts and tribunals, or even national courts and tribunals, but these are not the only actors that decide whether a customary rule exists and interpret customary rules. States also decide whether customary rules exist and interpret them. So they are also stakeholders in the existence and interpretation of custom. And my feeling is that they are the ones that need the flexibility, because they need to keep as many options open as possible. And I'm thinking, at least in my subject matter, of lawyers of ministries of defense, of legal advisors of armed forces, of a number of agents representing a state who have to tackle the question of existing or interpreting an existent rule of customary HR. Thank you.
Thank you, Hans. Any other members of the panel want to react? So, then we're up to the next question. Panos?
So thank you all. I don't know if I need to start, as Sotiris did, with whom I love. So I love you, Vios, but perhaps one comment from what you said last about the flexibility, the need for flexibility. And we had a similar discussion a few weeks back in Washington on investment law. And the argument there was that lawyers absolutely hate, detest trying to find and establish state practice and opinion juris for customary international. So interpretation kind of gives them a little bit more flexibility there to play around as a tool there, I think. Now, for reasonableness, I'll leave it for the next panel to discuss this in more detail. But let me move to other questions. The other person who is being loved by the questionnaires, Akis. So Aki, you mentioned the by proxy textual interpretation, so that you go to codificatory instruments and so on. My question there would be, don't you see a danger there, especially with the Colombia-Nicaragua case, where because it was considered that the main article there was customary international law, then they went crazy. Well, crazy might be a very exaggeration, but they really went for contextual interpretation to other provisions that are of a debatable customary law status. So then, doesn't that kind of, the by proxy textual interpretation kind of gives like a get out of free jail card, basically? Use this. And there, I have some doubts about whether methodologically that is correct, or whether there needs to be more care. To Seline, may I ask follow-up questions? No, not to Akis, but to other loved persons in the panel.
Please do.
Frans, I'll come to you, don't worry. Seline, yes, absolutely. One question there that I would have would be how, so this dialogue between the treaty bodies, and I'm not sure if there is an answer there, but how intentional do you think that dialogue is? Is there, I don't know if there is communication, you know, kind of not a strategy, but you know, a more intentional something behind the dialogue, or does this simply emerge organically? And the final question to Stavros as well. It's a very hypothetical, so feel free not to answer it completely. When you talked about evaluative interpretation of the rules, if I remember correctly, you mentioned that not all states were happy with these interpretations, right? So there, my question would be, what do you think does the concept of persistent objector apply in these kind of situations? Or you simply say, well, it's an interpretation, so persistent objector doesn't apply. That's it.
So you want to start?
Oh, okay, sure.
Or
I can.
yeah?
Yes. Okay. So on how intentional, I think it depends a moment on the case, of course. It's very specific to the case. I think that we find reference mainly to Conference of the Parties documents in the arguments of the parties to the case. Here I didn't mention during the presentation, but also the Philippines, for instance, in the memorials, they worked quite a bit with also those instruments. Then, as I mentioned, the court, at least from what I saw so far, does not directly reference the specific voluntary guidances of the CBD. At the same time, what I noticed is that it uses the steps and the reasoning. So of course I can only speculate, and I don't want to speculate because I don't know what went through the mind of the judges while they were drafting the judgment or the decision. But then I can make this comparison and say, well, this type of steps, this type of reasoning, this type of arguments, it's making its way in the final decision and in the way in which we are shaping the content of that obligation. And I think that is just happening. Then, as I said, I don't think there is a clear intention from the court. I think it's more from the parties that kind of present those arguments during the in the memorials and in the pleadings.
First Akis and then Stefan?
Yeah. So yes, thank you, Panos, for your question and the love, and also tears. So yes, you're right that there is the court does not actually ascertain whether it does, how it does interpret customary international law. Specifically, in the last question, the last case in the 2023 case, didn't say anything. It went just without any logic in going X, Y, Z. I understand the point that you say that there is issue with contextual interpretation, specifically when it comes to, Seline pointed out, Article 82, which also Charles Forth mentioned in her dissenting opinion that it's not we're not sure it's of customary nature. However, I think in terms of the previous case, this was more obvious because in the previous case I mentioned, when it goes to the contiguous zone, we have articles that they are well established, right, and also Article 56, 58. So I think that my point is that, also my suggestion is that it is law of the sea, specific law of the sea, because it has been we had the third conference for 9 years, so there's a lot of material to actually delve into. It differs from other kind of customary international law. For example, immunities of state officials, we don't have a text, right? So the principles, the rules that you are actually advocating are, I think, more amenable to this kind of situation rather than in the law of the sea context, maybe also in the international humanitarian law, because we have text. It is, I think, the first principle that by proxy interpretation has more actually weight than the others.
Thank you. A couple of comments, and then I will get back to Panos' question. Yeah, the first one about I was also noticing this, what you mentioned, Panos, about the identification of customary international law and someone going through this very laborious work of identifying that. It seemed to me like it's a delegation issue. You always, delegate it to someone else until an authoritative voice takes over, and then it says, with no evidence, or at least no substantial evidence, this is the law. And then what Takis mentioned, that it's difficult to depart from treaty interpretation. I agree in principle, and it appears to be the case for these branches of international law, if we can use this term, that are also driven by judicial holdings. This is not so much the case in IHL. That's why we had to resort to the ICRC, for example, Vios and myself, or the ILC. And it can also be the case that you may have inconclusive treaty interpretations to which you cannot resort in any case, so you can more easily depart from. And I have in mind examples I gave regarding contested interpretations of competing interpretations of AP1 additional protocol 1's terms. Now, Panos, to your question about the concept of persistent objector, I hadn't thought about it carefully. To be honest, my initial reaction would be that yes, somehow it would apply. On the other hand, I have in mind that these states, especially with respect to the occupation PERAC principles that objected to them, we had some vocal opposition coming from the US and Israel. And of course, the first line of argumentation would be, you know what, this is not customary international law in the first place. You're wasting your time if you start interpreting this term. This is not customary international law. Or the way they specified, and I'm now using Celine's concept, the specification, this concretization of general norms dating back more than a century ago, and its specification to the natural environment, or the environment as the ILC's preferred terminology. But then my short reply would be that somehow, yeah, my reaction is that yes, they shouldn't be bound by this interpretation of customary international law, especially given that consistently and from the first place they didn't subscribe to AP1. They have been consistently and persistently objecting to the status of this term. But perhaps you have to think more about it and consider also other examples and not these very hard position examples.
To be continued, Panos. Conrad, did I see that there were questions online?
I have a question to Seline. I really enjoyed your presentation because quite new, analytical approach, very nice. I have a question concerning your thoughts on environmental impact assessment in general, in relation to judgments of the ICJ. So in several judgments, the ICJ said that it's general law. In pulp mills in Costa Rica, Colombia cases. However, the judgments were very much criticized. That the court didn't give, especially in the first case, the court said that it's a general obligation under customary law, but the specifics belong to states. And states have to decide what is the substance. Not ideal. The second was that the court didn't really make proper division between procedural aspects and substantive aspects of the environmental impact assessment, came up with two-step EIA, first before even EIA, then EIA, and kind of confused. Jutta Brunner wrote a very nice article about it, how it was confused. So, okay, then the chamber of the ITLOS repeated it all, fine. However, the question arises, and I would like to know your thoughts, that due to very confused and contradictory and not very precise judgment of the ICJ, isn't it still better to rely on the environmental impact assessment in treaties, particular treaties, and the treaties should really precise and detail what they mean in particular case of environmental impact assessment, because as it is now in customary international law according to the ICJ, the question is it really usable by states, and what are the obligations, and can states rely on the judgment of the ICJ on environmental impact assessment? Thank you.
Intriguing question, but nevertheless, I hope I'm a bit short. Yeah, we could first do the questions. We have Hélène and we have online via Conrad.
We have two questions, one from Mei Yi. With the recent decision in Nicaragua versus Colombia, would you say that the new trend in interpretation of customary international law now is that opinio juris can be inferred by non-action/abstention of states from doing certain things? This question is asked on the premise that the decision is a departure from the North Sea to Continental Shelf and Chagos cases. And the second is from Dimitris Panousos. I have a question for Seline. When it comes to customary law, jurisprudence usually focuses on some minimum requirements for the conduct of EIA, which are state-centered, in the sense that states have higher discretion in the content of the EIA. However, we now seem to move from this approach to a more community-based approach, and for example, under the BBNJ agreement, we can indeed find higher standards when it comes to EIAs. So do you think that within this dialogue there's room to further expand upon those minimum standards in customary law and move from some state-based standards to some global minimum standards?
And then the final one by Hélène. Mike is approaching.
Thank you very much. I wanted to revert to the issue of persistent objector. I mean, the question came again. It was there this morning regarding Article 25 of the UN Charter, or 27, no, of the UN Charter. And I'm not never comfortable when you have this argument of persistent objector coming on the table. I know this doctrine is still has some room in the ILC articles on international customary law, but at the same time, if you look precisely at the Namibia opinion, I mean, the persistent objection of South Africa weighed nothing in the case. And so I'm always uncomfortable because this doctrine is always there. It's presented as authoritative, and now I would like to see it function. If you consider that it works just because people shy away from opposing a norm to the US, because they are the US, but not because the persistent objector doctrine is an efficient legal doctrine. You see my point. So I'm not very comfortable that it's broad game, and so that some states don't want of some norms, that's obvious. That it would not prevent these norms from emerging, that's obvious as well. That the doctrine of the persistent objector is a legal efficient legal doctrine is another debate. So I would like to bring back this, and maybe to get answers in taking into account what I've just said, and maybe get panel's feeling on that, whether persistent objector was a kind of pollution in his research. Like it is, no, but like it is every time you want to speak about customary law, because it's brought back as the voluntary trend of international customary law, the one to which you cannot escape, etc., etc. You have power relationship. Should it be converted in a supposed to be or alleged legal doctrine is something else. So this is where I would like, I'm deliberately provocative there, but I would like to get a bit more controversial answers. Thank you.
I propose a final word by Panos on the persistent objector. Yeah, but maybe before that, we start with Seline, okay, and then Agus, and then you're the last one, Panos.
I'll use this one. It's easier. So,
then
meaning that you can take your time.
Yeah.
So thank you, Malgosia, for the question. It's a long discussion that we can also have during the coffee break. I agree with you about the ICJ judgments, and indeed I find actually decisions from other courts more telling than the ones of the ICJ, which I think I find when I read the judgments of the ICJ, it's sort of like as if the judges were not at ease to discuss really the content of this obligation. Already they were very timid in saying that it was customary international law with this expression in the pulp mills, And then in the next case, it said, okay, we have the rule now, just saying a bit what it is about, but not too much. And then it's taking a long time. And indeed, when we have the support of a treaty, which is specifying and detailing the content, it works better and faster. At the same time, I do think, of course, it's important that the ICJ kind of affirmed it, so that it allowed also other courts and other bodies to kind of take up also that role of like, well, the court has said it, so I can move forward. We accept it as custom, and then we can, you know, build on it. And that's a bit what I find is happening in the South China Sea Award, for instance, but also in the Inter-American Court of Human Rights, and even the discussions that are right now ongoing in terms of, well, climate change and so on. There is this important dialogue between the courts specifically. Thank you.
Maybe
yes.
a short answer to the question via Conrad?
Yes, yes. Hi, Dimitri. I know Dimitri is a former student of mine. Thank you for the question. So I wouldn't go so far as to say that under customary international law we see now the formation of like global standards for the content of EIA. That would be pushing it too much. I do see, however, that the content of the obligation is being detailed in more and more fora, not only courts, but fora in the sense of also treaty bodies and different other entities. And I think there is a sort of maybe agreement emerging on what is the content of the obligation. And as I said, I do think that the steps, at least, of what EIA should imply are becoming more and more accepted in the practice. And we see it also at the domestic level, when there is the analysis of what states are doing and the type of legislation that they are adopting, and when they are reporting back to the treaty bodies about the implementation of those obligations at the domestic level, we see that this is happening. And it's not only within the CBD, it's also within the other treaties. So the Ramsar Convention, the CMS, the CITES, and so on. So I think that those standards are emerging, and let's see how the next case will deal with them. Thank you, Dimitri.
Thank you, Seline.
Yes.
How do you want to deal with the question on the law of the sea?
Yes, yes. Thank you, and thanks for the question. It's, as Panos mentioned, this case has been, it has been subject of a lot of criticism. I think that the court had already in his mind, the majority at least, that he won't accept, extending continental shelf under customary international law. This is my view. So it tried to, justify its views and its reasoning, and when it went to the Nicaragua, and Colombia, mainly Nicaragua, put forth a lot of state practice with respect to submission to the Commission on the Limits of Continental Shelf, and the court there had to say whether this is, affirms the customary international law. So the crux of the matter was the abstention by states of actually going into the EZ of other states when they are actually claiming an article in itself, where this actually reflects custom. And the court there in paragraph 77, as I said, I think it made a huge mistake, and has been also criticized in terms saying that when it comes to opinio juris, says that the statements, there is practice of states abstaining from claiming an extended continental shelf in these circumstances, and and this also reflects opinio juris, even though the abstention is not only for legal reasons, it's mainly for actually practical reasons. So the opinio juris, as we all know, in terms of we need to have this legal conviction, was absent in the reason of the court, and this has been, I think, criticized also by Tomka and by Charlesworth. So I think this was a bad decision in these terms. Even though I think that in general, I'm in favor of the final outcome of the case, but in terms of methodology, in terms of interpretation, in terms of custom, there is a lot of problems there in the case.
Thank you, Akis. And then maybe finally, shortly, Panos on the uncomfortable feel that I land with the persistent objector.
Yeah. So I don't know if what I'm gonna say is controversial, but to be honest, I don't think the doctrine of persistent objector polluted the project because in my view, it simply doesn't apply. It's as simple as that. I take a very positivist approach here that interpretation, basically, the rule already exists. You're just playing around with its content. So the doctrine of persistent objector does not apply in this particular case. The rule exists. If you're going to invoke the doctrine, then it will be at the stage of formation of the rule of customary international law. So then I would think, although to be honest, we haven't come across that possibility in our research, or at least nothing comes to mind, of states claiming that they were persistent objectors to an interpretation. Most likely they would go the other way of there is no such rule. But when you're going in the direction of interpretation, then I think the doctrine of persistent objector simply ceases to be of any relevance for this particular exercise.
Thank you, panels. So we come to a close of this second panel. I must admit, panels, after listening to Stavros and his point when it comes to the civilian character of the environment and the protection of the environment, I rest my case with their environment instead of the environment. I hope you all enjoyed it. I certainly did. Wonderful panel, lively discussion, and you taking part in questions, super. And of course, a big thanks to the speakers. I will say an applause for the speakers. And we go to the tea.
Yeah, we have coffee and tea, and we should reconvene at 1:45.
So a short tea.